Yeah, good morning, students. This is Sreekanth, Assistant Professor, Dr. Ambedkar Global Law Institute, Tirupati, signing in for company law. So, yesterday we have discussed about who is a promoter. Promoter is a person who thinks of forming a company and actually brings the company into existence. He is the person who originates the idea of starting a business. He plans the formation of a company and actually brings it into existence. He is the person who does the necessary preliminary work incidental to the company. In simple words, we can define he is the person who brings a company into existence. Now, whether a person is a promoter or not is a question of fact in each case. For example, Infosys company is there. So, who is the promoter? Narayana Murthy. Tata company is there, Ratanji Tata. They are the promoters. What they will do? Infosys company, Narayana Murthy has conceived the idea of forming the company and he has started Infosys company. That means he is the person behind the Infosys company. So, promoters are responsible for the formation of a company. They bring the company into existence. As such, promoters occupy important position. Now, the legal status of the promoter is concerned. He is neither an agent nor a trustee of the proposed company, and he stands in a fiduciary relationship with the company. Right. Now, promoter, you know that promoter is the person who brings the company into existence. Now, there are certain functions of the promoter. Let us discuss those functions. Now, he is the person. So, to originate the idea of starting a business and forming a company, suddenly a idea strikes his mind and he thought of forming a company. He is having the money. So, now what happens is he will investigate the idea and know whether the formation of the company is possible and profitable. So he is having money. So he will research different types of companies, whether to establish a public company or private company, one person company, and so on and so forth. And he will investigate the possibility and the profitability of the company. Now what happens? Then he will collect the requisite number of persons. Requisite number of persons means, a public company should contain minimum 7 members and private company should consist of minimum 2 members. So he will collect the requisite number of persons necessary for the formation of the company and he will find out the first directors. So the company on its formation, director should be there. He will select the directors. If the directors are not selected by the promoter, then these 7 subscribers in the case of a public company and 2 subscribers or 2 members in the case of a private company shall be deemed to be the first directors. So now he will collect the requisite number of persons necessary for the formation of the company and to find out the first directors. Now, and next one is to settle the name of the company. Remember, you cannot put any name to your company. First, you have to select 6 names of the companies. You have to send it to the registrar of companies, and after getting approval from the registrar of companies, you can select the name of your company. Now, you cannot put to your company, a private company or whatever it may be, the names like Bharat, India, Mahatma Gandhi. You cannot put this name. Why? It is against the public policy, and we are having one act is there. It is Names and Names and Emblems Act. Names and Emblems Act. It should not go against those acts. Now you have to settle, you have to select the name of the company. Now after getting approval from the register of companies, then only you can have your company's name. Next thing is we have to prepare the memorandum and articles of the company. So you know that memorandum contains six clauses: name clause, registered office clause, object clause, liability clause, capital clause, and last one is subscription clause. You have to prepare the memorandum of association. He will prepare, and articles of association of the company. So he is going to prepare the memorandum of association and articles of association, and he will get these documents drafted and printed and to arrange for the registration of the company. Now he has prepared memorandum of association, articles of association. Next thing is he will arrange for the preparation of the prospectus and its issue. He will prepare prospectus. Prospectus means when a company wants to issue shares to the public, the application for the what is called subscription should contain prospectus. Prospectus contains name of the company, who are the promoters, who are all associated with the forming of the company, so on and so forth. How you are going to invest the amount that has been received by way of shares, everything. So you have to prepare the prospectus also, and its issue. Prospectus, once you prepare, you have to send the prospectus to the Securities and Exchange Board of India, all the stock exchanges, register of companies, and get approval. You have to do this. Then you will, this promoter will enter into preliminary contracts. Preliminary contracts are those contracts which have been entered into by the promoter, from the stage where the company does not come into existence. So preliminary contracts that has been entered into by the promoter from the stage where the company does not come into existence. He will enter into preliminary contracts for land and machinery, raw materials, buildings, employees, directors. He will enter into all the necessary contracts for the formation of the company, and he will pay preliminary expenses also. So simply you cannot form a company but without paying any fees. For name approval you have to pay fees to register of companies, approval of prospectus, memorandum, articles, capital, everything there is a prescribed fee will be there. Unless and until you pay the prescribed fees, your documents cannot be registered. So you have to incur certain expenses to make the company comes into existence. So he will pay preliminary expenses also. Then if the company wants any loan from banks or financial institutions, he will arrange for loan etc. from various financial institutions. Then to perform such other functions as are necessary for the formation of the company, and he will conduct the negotiations for the purchase of business where it is intended to purchase an existing business. So these are the functions of the promoter. Now apart from these functions, even there are certain duties and obligations that has been cast on the promoters. Now a promoter can sell his land to the company, right? A promoter can supply raw materials to the company. There is no legal bar. However, the promoters must not make directly or indirectly any secret profits at the expense of the company which they are promoting. For example, promoter is having a land worth 1 lakh rupees. Now he cannot sell it the same to the company for 3 lakh rupees and makes a profit of 2 lakh. He can do so, but he has to disclose fully all the material facts regarding the formation of the company. If any promoter makes any secret profit, then company may file a suit against that promoter and the company may recover the same. The promoters must disclose fully all the material facts regarding the formation of the company. So they have to faithfully disclose all the facts relating to the property which they want to sell to the company. Even they should disclose their interest in such property. He has disclosed his what is called interest in the company. He has disclosed his interest to the what is called shareholders. Now he has disclosed the facts as well as the interest to an independent and competent board of directors or to the whole body of persons who are invited to become the shareholders of the company. He can disclose or in the prospectus of the company or in the articles of association of the company. He has disclosed the fact as well as his interest in the company. If the promoters make any secret profit without disclosing the full facts, then the company may resign the contract made by the promoters. Now, what happens? The company may cancel the contracts with the promoters if the rescission of the contract is not possible. That means where the company is not in a position to return the property, then company can recover the secret profits from the promoters. Now the promoters even they must not make unfair use of their position and they must disclose the company their true position. So promoters must act honestly. So now for this what is called they are the persons who form the company and apart from the duties there are certain liabilities of the promoters will be there. So if the promoters make an untrue statement in the prospectus, they are the liability arises two types: civil liability, criminal liability. They are liable to pay compensation to the subscribers for damages suffered by acting on that untrue statement. They are also criminally liable. So straight away you cannot say that they can escape from the liability. So even promoters have certain liability: civil liability and criminal liability. Now they have formed the company, then what they are deriving from the company means they can get remuneration from the company. So the remuneration may be given in cash or by allotment of shares or partly in cash and partly in shares. Normally, usual ways of paying remuneration to the promoter for his services are he may be paid certain lump sum amount or he may be given shares of the company. He may be given commission on the shares sold by the company. He may be given an option to buy the shares of the company at par when the market price is higher. He may be paid the commission on the purchase price of the business or property acquired by the company through him. He may sell his own property to the company at a higher price and earn profits. However, the profits in this way can be earned by him only after making the full disclosure of facts. So, we have defined the definition of the promoter, his functions of the promoter, duties of the promoter, liabilities of the promoter, and remuneration of the promoters. So, in fact, the role of the promoter is he stands in a fiduciary capacity. Remember, he is neither an agent, nor an principal, nor a trustee. That means whatever he derives from the company, he is accountable to the company. So this promoter is very important from your examination point of view. Alright students, now move on to next topic. It is known as pre-incorporation contracts or preliminary contracts. Now, pre-incorporation contracts are those contracts which are entered into by the promoters on behalf of the company before its incorporation. So before the incorporation of the company, promoters usually enter into certain contracts for the purchase of assets on company's behalf. Normally, pre-incorporation contracts are not binding on the company even after its incorporation. The reason for the same is that before incorporation, the company is not competent to enter into the contract as it had no legal entity. Thus, a company cannot be sued for the pre-incorporation contract. Company can neither be made liable for the pre-incorporation contracts nor it can take the benefit of these contracts, and however this is subject to the provisions of the Specific Relief Act 1963. The even Supreme Court has also held that company has no status prior to its incorporation. The company is also not entitled to sue on pre-incorporation contracts. Now you know that pre-incorporation contracts are those contracts that have been entered into by the promoters even before the incorporation of the company. So now liability of the promoters for pre-incorporation contracts. Pre-incorporation contracts can be enforced by or against the company if they are made for the purpose of the company and within the scope of company's objects, and company adopts them after incorporation. Company will tell to promoters, I am going to adopt your contract, then only company is liable. The company says to the promoters that I am not going to adopt your contract, then company is not liable, promoters are personally liable. So the liability of the promoters depends upon the facts and circumstances of the case and the construction of the contract. So if the promoter is personally liable, he purports to act as an agent and non-existence of the company is known to both the parties. However, the promoters may avoid or escape their liability by inserting some clauses in the original contract. If after incorporation the company adopts the contract, promoters shall be discharged from all liabilities. If after incorporation the company does not adopt the contract within a specified or reasonable time, either party, promoter or third party, may rescind the contract. So, you know that pre-incorporation contracts are those contracts that has been entered into with the company even before prior to formation of the company, which does not have legal existence. Even the Supreme Court has also held that a company has no status prior to its incorporation. So promoters may make preliminary contracts or pre-incorporation contracts. After the company comes into existence, it has to adopt the contract. If the company don't adopt the contract that has been entered into by the promoters, then promoters are personally liable. If the company adopts those contracts, then company is liable. This is based on the principle with respect to provisions of Specific Relief Act 1963. Sometimes the promoters of a public company have made a contract before its incorporation for the purposes of the company. In such cases, the company may enforce the contract if it is warranted by the terms of incorporation. Warranted by the terms of incorporation means within the scope of company's objects as stated in its memorandum of association. Moreover, the contract must also be for the purposes of the company, that is, for the working of the company. The other party may also enforce the contract against the company. Third party, that means promoters have entered into contracts with third parties to make the company comes into existence. So other party may also enforce the contract against the company if the company has adopted the contract after incorporation and it is within the terms of incorporation. So, if the pre-incorporation contract is for the purposes of the company and within the company's objects that has been enshrined in the memorandum of association, it can be enforced by or against the company if the company adopts the same. So, if the company adopts pre-incorporation contracts can be enforced, otherwise promoters are personally liable. Students got something today. This is Sreekanth signing off today. Have a good day.